It's this weird duck thing. You notice that? Up in the
What do you
left-hand
mean?
corner, it's like a duck. If you put your
Ah,
cursor over him, he
it
moves.
moves. That's a new one.
It's a new one. Yeah. Scenes panel. What is that? Ooh. Demo scene.
Hold on, I'm almost done
Yeah.
splitting this up.
Yeah. I want to do that. Weird.
Okay, guys. Everyone should be going to CrimeCon in Vegas because I just heard from like several of my girlfriends. We got to look for a Vegas show. Brett, you're invited, but they're all showing up in Vegas. No one shows up anywhere else. I'm not gonna lie. I don't
Why
think it's me they're
Vegas?
coming to see. Huh?
I mean, of all
It's
places.
easy. It's actually like easy to get to
Oh,
for everybody, you know.
I guess that's true. It is easy to get to. All right, I'm ready whenever you are.
I'm thinking of a descriptor.
Okay.
Okay. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my, sorry, that was a little weird. Okay, welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my deja vu of a co-host, Brett.
Alice, it's like the day that'll never end. Richard Allen versus the state of Indiana. I feel like
I'm
we
not
just
gonna
keep
lie.
coming back here.
When I started reading the 94-page appeal order in the conviction of Richard Allen, who was convicted for the double homicide of two young girls going on a hike broad daylight in February in Delphi, Indiana, I thought, haven't I read this a million times before? And all the people who say the justice system is just stacked against the criminal defendant, you should be heartened that despite having a record so clear in support of a conviction, Richard Allen does have these appeal rights, and he gets to rehash these arguments over and over and over and over and over again, and they are engaged ad nauseum by all the courts, because this is a 94-page opinion that you should go read or don't, because brief. Sorry, brief.
I wish you were an opinion. It's just
sorry, brief. I get so excited that I think, of course, it should already be there. That you might think, I've already heard these arguments, and you have, but there are different courts that you can appeal to, and that's exactly where we are, because Richard Allen has appealed and the state gets to respond. So this is, I was hoping this was the opinion. This is the response of the states to Richard Allen's arguments, which, by the way, if you followed this case, they should all sound familiar to you because it is not on first impression.
We talked about this a little bit when we did his brief, the appellant brief. When you're doing an appeal, there really shouldn't be anything new. There, you would see sort of clickbaity headlines about new arguments or new evidence or whatever, but you don't actually have that in appeals. It's all based on the record at the trial, which actually becomes important in this brief. We'll talk about that in a second, but it really should all be things that you've heard before. And look, one of the things about the justice system, and we've talked about this before, everybody wants to talk about how it's stacked against defendants. And to some extent it is, particularly after you've been convicted. The standard is really high to overturn something. But one of the things that's always so striking to me is the lack of finality for victims and victims' families. And, you're the family here, you go through this trial, you see the end, you have 12 citizens who find someone guilty, you feel that rush of relief and you celebrate and you think, okay, that's the end, but it's not. And in true crime, we often treat the end of the trial as if it were the end, but it's not. And you have these appeals and that's great. That's part of the system. And we want that to be the case, but they're going to live this for probably as long as Richard Allen is alive, because this is the main appeal. This is about the trial. After this appeal will be the collateral attacks. We talk about those sometimes. Ineffective assistance of counsel will be one of those claims. There will probably be, over the decades, a trickle of new evidence style claims. And just think about the Scott Peterson case. I mean, how long have Lacey Peterson, her family, how long have they dealt with seemingly endless appeals and attacks on his sentence, and they go on to this day. That's the way it's going to be for Richard Allen. So this is, in some ways, it feels like, man, this has been going on for a long time. But in some ways, this is almost early days in the appeal collateral attack portion of this. We did an episode on the appellant brief. Listen to that. We made a lot of predictions about what the state would say in response, and a lot of those predictions came true. You see a lot of that in this brief. I will say we're going to walk through this a little bit, but just sort of a general thoughts on this, Alice. One thing about the state's brief as opposed to the appellant's brief, and you see this a lot, much more buttoned down, much less dramatic, not as much flair. You know, they have a fact description of the crime. There's some very well written passages, but you don't have quotations from books, Nelson Mandela, citations to, prisoner of war camps. You don't have that kind of stuff in a state's brief, and you often don't see that kind of thing.
Yeah, I think that's exactly right. And honestly, I think that's appropriate for the state because, as we've always said, trial court, really, it is the best story that wins, right? There is an element of litigation that is storytelling, and it's not storytelling making up stuff, but it is how you convey the information to a jury. But we've always said that the prosecutor should be held to a less dramatic standard because it shouldn't be the most dramatic story that wins. It should be that beyond a reasonable doubt evidence supports the conviction. So, I mean, truthfully, you get more liberties and like storytelling and flair for the dramatic, even in your appellate briefs when you're the criminal defendant's attorney. So if you want to be like more of a creative writer, I really mean this, like you might want to consider defense work because you are able to use that creativity in the right way. It doesn't mean that Brett and I aren't creative, but to be totally honest, when we edit each other's briefs, I'm like, Brett, that's a little spicy. Got to take that one out. I really like that zinger. But this is not the place for the zinger because it is based on the facts. That doesn't mean all prosecutors are like that, but I will say that's how we practice.
Yeah, just to give you an example, the statement of the facts in the appellant's brief, number one, the appellant's brief goes on for 113 pages. So it's about 20 pages longer than the state's brief. That's not a ton longer, but it's, a little bit. But the statement of facts in their brief starts on page 10, ends on page 57. The statement of facts in the state's brief ends on page, 25. So it starts, it starts on page 11, ends on page 25. So, just a much longer statement of facts in the appellant's brief. And I think that's just sort of an example of how it's often a little bit more dramatic in their brief. But here's the thing, and this is sort of a practice tip if you're a lawyer out there. If you have the stronger position, make it as short as possible. Hit the points that are powerful and move on. Because I think that really is convincing to an appeals court. And, it's kind of like you watch somebody getting into an argument online, two people going back and forth at each other on Twitter, and it just goes on and goes on. And they're both like throwing barbs and it's going back and forth. Unless you're invested on one side or the other, usually you just think, man, what a bunch of bozos just going at it, right? That's not convincing to you as a third party observer. And I feel like it's the same thing for courts. I mean, a lot of times people who are writing briefs, they want to go at each other. And I really don't think that's very effective. And I think this brief is sort of an example of that. I mean, they land some pretty strong punches on Richard Allen, but I don't feel like they, went after the other brief or anything like that. And I think that was smart of them. Okay. So let's talk about, in big picture, the brief. It's 93 pages. We're not going to go through the whole thing. Murder Sheet did 2 episodes on this. They read a lot of the brief. So if you're interested in hearing some of that, we're going to read some of the brief too, because one thing that I thought was really fascinating about the state's brief, the law, not really that much in dispute. We talked about this some in the appellant brief. They reached at times for the law because They really wanted the law to be more on their side. I don't think those were very successful. The state points it out. But one thing the state spends a lot of time on is just clarifying the facts. Because when the law is pretty clear and agreed upon, the facts are really going to tell the story. And you see that a lot. And so we will be reading some of this brief, specifically some of those facts. So the first thing that was attacked by the appellant, and typically, if you're the appellee, unless there's something weird going on, you typically kind of go with the appellant. The appellant's laid the ground. This is where we're going to fight this battle. This is our strongest argument. We're going to put it first. And you sort of follow along and do the same thing. And they did. The first thing in the appellant's brief, and this surprised some people who thought it would be more Odinist, was this search warrant for Allen's house. And you may recall, we talked about Frank's motions, Frank's hearings, and how if you're going to attack a warrant, you have to say, hey, the affidavit in support of this warrant had some big issues. Either there are intentional lies, there are intentional significant material omissions, and they're so bad that if you took out the lies or you added in what was omitted, you would not have probable cause. Therefore, the search warrant is invalid and the search should go away. And that was one of the big attacks in the appellant's brief. And one of the things we pointed out was how the appellant's brief was making a better Frank's motion argument and a more thorough argument than the trial counsel had done. And that because of that, you saw the appellant doing the appellant's brief, which was written by different lawyers, really trying to work to make their arguments fit in the appeal. And the state recognized that and came back with that. And if you read the state's brief, and I think you all should, one thing that you'll notice again and again and again in every single argument, and I think, frankly, if you're someone out there who thinks Richard Allen was wrongfully convicted, should make you angry, is how little his trial counsel did to preserve issues.
And remember, this is incredibly important because we've said all along, trial, as much as it may seem on TV or in dramas, there are no gotcha moments, and there are not supposed to be any gotcha moments. It is a fair game where the facts are supposed to be able to duke it out. And that's why preservation of issues is so important. And if you remember the, 127-page Frank's motion, I can't remember exactly the page number, over 100-page Frank's motion, which was titled a Frank's motion by Richard Allen's attorneys, was meant to attack the four corners of the search warrant. But remember how we said that there was actually no mention of the law. It was a storytelling endeavor. It was a press release about the theory of Odinism rather than attacking the search warrant. And there was so little law in there. And not only that, they never actually attacked the search warrant. And at trial, it was not objected to, in fact. And that is a huge problem because you have to object. When you watch cases, people ask this all the time, and a lawyer keeps saying, "Objection, Your Honor, objection," and the judge kind of like, "Oh yeah, overruled," and people are asking, why is this there? Why are they just saying objection? Nothing's happening. Is it just to be annoying? No, it's to preserve these issues for appeal, and you have to do that.
And sometimes you'll hear them talk about a continuing objection, so they'll object. And this is annoying sometimes if you're just a layperson watching it and you're like, God, he just keeps going back to it. And they'll say things like, Your Honor, I'm just trying to preserve the record. And the judge will say something like, your record is preserved. I have your objection. And the reason that's happening is because in a lot of states more than federal practice, frankly, in a lot of states, they have very strict procedural rules that you have to preserve these objections. And think about the reason why that might be. Okay. So you file your Frank's motion and you're making all these arguments, and they're really about Odinism, but you're making some arguments about the search warrant too, trying to get it kicked out. And that fails. You don't keep it out altogether. Well, just because you objected to it in a Frank's motion at the time doesn't necessarily mean that once you get to trial, your strategy hasn't changed. You may think, look, if we could have kept the whole thing out, great. But if we can't keep it out, then I want it to come in so I can point out X, Y, and Z for the jury. I couldn't keep it out as a matter of law, but I can weaken this case by attacking factual points made in the affidavit, made in the warrant. I can go after those things. So I actually don't want to keep it out now that we're at trial, right? So, and the courts are thinking that those are the kind of strategic decisions that the attorneys make all the time. So just because you filed a motion pre-trial attacking a piece of evidence doesn't necessarily mean that the strategy wouldn't change. So if, for instance, a piece of evidence that is subject to this search warrant that you challenged in a Franks motion is about to come in, and you say, which they did, no objection, Your Honor. Not just you failed to object, but you affirmatively say when it is offered by the state, no objection, and that comes in, and then you turn around on appeal and try and say that should never have come in. We want to argue all these reasons. There's a really good argument that the state can make. No, you waived that in open court. You could have reaffirmed your objection. You didn't do that, so you can't now raise it in the appeal. The reason being, the judge didn't get to deal with that contemporaneous objection. And you want to do that in trials. You don't want to play gotcha games where you save it till the appeal and then spring it on everybody. Now, I actually don't think this will work, and I'll tell you why. Courts are really inconsistent with these kind of procedural objections. If this were a shoplifting case, they would say, this is waived, appeal denied, sign it, per curiam, send it out, right? They would get rid of this on procedural grounds. This is a double murder homicide case where someone's been sentenced to prison for the rest of their lives. It is probably not the case that they're going to decide it on procedural grounds. They probably will either just say, for the purposes of this appeal, it was good enough that they did the Franks motion, and so we're going to decide it substantively, or they'll say, regardless, they have raised this argument, we're not going to address that because on the substance, we find in favor of the state. And since either way the state would win, we're not even going to have to worry about the procedure. Courts are more and more hesitant to decide big ticket questions on procedural grounds, both because it feels like it's a little, kind of gotcha. Wasn't the lawyer's fault, number one, or wasn't the client's fault, number one. And number two, lurking in the background of all this is ineffective assistance of counsel. And I think everyone should be concerned. And there were times where I almost felt like the state went a little too far on the procedural stuff in this brief. If, for instance, imagine a world in which the appellate court said, wow, this is a great argument. Substantively, this should never have come in. Obvious violation of his rights. Wow, only a total idiot wouldn't have raised this, but unfortunately, they didn't raise it. They said no objection. It came in. They've waived it. Therefore, appeal denied. I mean, that is like serving up on a platter an ineffective assistance of counsel claim. So I think regardless of what happens in this appeal, we're going to get past the procedural question to the substance of the issue. Okay, and the substance is, this is Frank's challenge. Remember, you have to allege either you left something out or you lied about something. It has to be basically deliberate or so reckless. It's like reckless indifference to the truth, very high bar. There are two primary facts that they have said were lies in the affidavit. One of them is the detective Liggett made false statements in the affidavit. He claimed that an interview was done of Sarah Carball in 2017, and she stated she saw a man wearing a blue-colored jacket who was muddy and bloody. This is according to the appellate. In her 2017 interview, Carball did not describe the man as bloody, only muddy, and she said he was wearing a tan jacket. So these are two lies that Richard Allen and his counsel say were in the affidavit that if they had not been included, if the truth had been included about what she said, no probable cause, warrant goes away.
So like Brett said, I do think they're going to go to the substance of this. So they do deal with the substance of it, and they deal with it in two ways. They deal directly with whether these are lies, and then secondarily, whether it matters at all. So first of all, we've said this before. Carball testified that in her first interview, she did say that the man was bloody, but that the recording didn't catch it. Remember, this was actually a pretty long interview. She was mumbling for some of it, and at least an hour of the interview wasn't recorded. But honestly, you don't even need that, because Allen conveniently ignores that she was interviewed not once, but 3 times before the preparation of the affidavit. So the state cites to those other transcripts and notes that she does describe the man that she saw as bloody 16 times in one interview alone. And she said that this man looked like he'd slaughtered a pig, and even noticed where she saw blood spatter on a picture of Bridge Guy. So in her second interview, she corrected that it was not a tan coat. Rather, it was a blue coat with a brown or tan sweater or hoodie underneath it. So what the state is doing here is, this was not a scattershot or like rushing to the court situation. They did a very thorough interview of Carball, not once, but 3 times. And we've talked about how when a witness is interviewed, especially honestly, when they're telling the truth, it may take some time for them to recollect exactly what it is they saw. Now, Carball saw this person. It was disturbing because she says that it looked like this man had slaughtered a pig, but she's not staring at him for hours at a time. It's in passing, and she's talking about this after the fact. So you see how they get to this point, and these are not obvious lies. This is not that reckless, disregard for the truth. The high standard it takes in order to satisfy the Frank's motion standard.
And, you may be saying to yourself, well, I mean, if she only said it once in the first interview, and then she said it a bunch of other times later on, and she said tan in the first interview, but then she said, well, actually, it was a blue jacket with a tan undercoat. Well, that goes to her credibility, and that's something that she could be challenged on, et cetera, et cetera. Absolutely, 100%. You do that at trial. That is what she would do, and what the defense, in fact, did do during cross-examination of Sarah Carball. They went after her credibility. They went after the fact that her story changed. They went after the fact that shouldn't the story be most fresh in your mind the first time you tell it? Isn't it interesting that the facts changed to more closely match the state's theory after several interviews? They did all that, and that's for the jury to consider. Those are all credibility determinations. This is not about that. This is about whether or not there's probable cause or not to go after Richard Allen. And we're going to talk about why there is and what the state says about that more in a second. But just recall, why is this important? This is important for a couple reasons. To establish that the man Sarah Carball saw was Bridge Guy. I mean, that's one of the main things. The fact that he's bloody helps establish that. The fact that he's muddy. The fact that he's wearing a blue coat. These are all important things. And she's seeing him at a time that connects to Richard Allen. But she really has a pretty minor part of this. And so the state is doing what you always do, multi-tiered arguments. You don't put all your eggs in one basket. So the state says, look, this was waived. Even if it wasn't waived, there's no lie here. She told them at various times he was bloody and muddy. She told him he was wearing a blue jacket. They put an affidavit. It's fine. You want to quibble with this and say, well, they should have said for the first interview, she only said he was bloody once. Well, the first interview, she said it was tan jacket. Second interview, she said it was a blue jacket, tan under sweater or whatever. That's not what Frank's is about. It's not about quibbling about these facts. It's about big picture, big ticket, really exceptional lies told by a police officer to get a search warrant they shouldn't be able to get. So that's never going to get you there. But the other problem and what the state hits on is take Sarah Carball out of it. Okay, fine. Take out her description of muddy blood. Because remember, it's not that she says, I saw Richard Allen that day and he was muddy and bloody. That would be a huge deal, right? This is just one part of it, connecting Richard Allen to this because of where he parked and where he would have walked and everything else. The brief goes on to say, here's all the reasons we had probable cause to think Richard Allen might have been involved, and thus were able to get the search warrant. And they say it was Allen and not any witness who provided the probable cause. And I'll just quote what they say. It was Allen himself who provided the reasonable ground for believing he was the man these witnesses saw, and thus that he was Bridge Guy. Allen originally told police that he was on the trail between 1:30 and 3:30 p.m. He said that he passed a group of girls without speaking to them as he walked towards the high bridge, that he went out onto the first platform on the bridge, and that he did not see Bridge Guy while he was there. Thus, Allen had placed himself on the trail and on the high bridge platform at the same time the witnesses saw a bridge guy there. Moreover, although he could not recall with certainty by the time he was interviewed in 2022, Allen told police that he was probably wearing blue jeans and a blue or black Carhartt jacket that day, which was consistent with the clothing Blair saw and bridge guy was wearing. And I think if you've been paying attention to the Richard Allen camp and the people who speak on behalf of them, there has been a notable change in their argument about this. More and more of them have begun to say, maybe Bridge Guy didn't do it at all. Maybe Bridge Guy he just happened to be there. He just happened to get filmed. He's just giving them directions. They're trying to figure out how to get down. And he's like, guys, down the hill, just being helpful, right? And he wasn't even a killer. He was just a friendly guy. And I think the reason you're seeing that is because this information and the way Allen gave it ties him so closely to Bridge Guy, it's almost impossible to say he's not Bridge Guy. So you have to start arguing maybe it wasn't Bridge Guy at all. Richard Allen might have seen the girls, given them some directions, and then went home. And then the true murderer came along. Maybe he was waiting below. Maybe he crossed the bridge after Richard Allen left, et cetera, et cetera. And I think that's why you're seeing that, because these facts are so damning.
And we said this all the way back before the trial, that this is so damning because you have all these witnesses and they quibble about who saw what and at what time and if they were skinny or it's an old man, young man based on the sketches. Who cares? Richard Allen's own words put him there. And there's another thing that Richard Allen does, that he tries to quibble around and say, oh, there's all these witnesses. They have varying descriptions of some car parked at the CPS building. Completely irrelevant, these attacks. You know why? Because Richard Allen himself puts his car there. So the brief says, quote, similarly, it was Allen himself who provided probable cause to believe it was his car parked at the old CPS building between 1:30 and 3:30 p.m. because he told police that was where he had parked and that no other car was parked there. This was corroborated by the Hoosier Haverstore video, which showed a car matching Allen's Focus driving towards the CPS building at 1:27 p.m. And this was consistent with his wife's information that they usually parked at that location when they walked the trail. Again, going back to Allen's being like, that's wrong. They couldn't have seen this. They don't know that. Okay, your own wife, by the way, who didn't know about this beforehand, said this is where you guys parked when you went on the trail. Huh, interesting. You know this trail. You go on this trail a lot. You have a picture of this trail in your treasure box in your room that we found during the search warrant. And you yourself said, I parked there. And remember when he was asked, were any other cars parked in the parking lot? He said, no. So not only did he say he was the only person on the bridge wearing exactly what Bridge Guy was wearing at the exact time that this murder would have happened, these murders would have happened, he also puts his car as the only car. He doesn't try to make up that. I mean, he doesn't tell a lie because he doesn't know this matters until later. No other cars, no other man. It's himself with his own words, putting himself there.
And I think it's important to recall, if you're coming into this, we think about these cases as, well, what happened? Who did it? Did he do it or not? Is there enough evidence that says he did it or not? And that's important. And obviously that's what a trial is all about. But we're at the appeal stage. So maybe you've heard all that and you're like, oh man, I don't know. I mean, I hear what you're saying, but still it seems like there's problems with the identification of the car, and maybe saying a car ball is not really that believable. That's all well and good. But the problem is those decisions have been made by the jury. The jury has looked at her credibility, apparently found her credible, because they then convicted. At the appellate stage, we're really talking about, I mean, you can have a totality of the evidence challenge. And I think there's one thrown in at some point here, though it's never that explicit. But what we're really trying to figure out is, were the defendant's rights violated in such a way that he should get a new trial because his rights are violated? One way that his rights could be violated is if his Fourth Amendment rights were violated because his home was searched without a proper search warrant, and they got evidence that they then used in trial and that tainted the trial, and we need to kick that evidence out and have the trial again. And if a jury convicts him without the evidence, okay, fine. But we can't know that because this tainted evidence comes in. So that's what this is about. The only question is, was there sufficient probable cause to search his home based on what they're hearing? And probable cause, remember, it is not It is not on the floor, but it's a low bar. We talked about this. It's one thing that I find humorous about the whole Richard Allen thing is that there tends to be a lot of overlap between people who supported Kieran Reed and people who support Richard Allen. And the people who supported Kieran Reed think you should be able to search someone's house for basically like there's somebody who appears to have been in an accident, hit by a vehicle in the front yard. That's enough to search your house under the Kieran Reed theory. Maybe it is. Maybe that's enough. If that's enough, then putting yourself at the scene of a crime, wearing the clothes of the person who committed it, who was spotted by other people, saying you're that person, talking about seeing those same people who saw you, then saying that you always parked your car in the place where the suspicious vehicle was parked and the person who was muddy and bloody was walking back to after the murder would have happened. Saying all that, supported by your wife, who says whenever you went to the trails, that's where you parked. That's probable cause. Like, there's no question, which is why you have to go at it from the Frank's motion perspective. You cannot, that is probable cause. So you have to be able to knock some of that stuff out. You have to be able to say, well, actually, half of what Brett just said are lies. And we know they're lies because of all these reasons. And that's why we're in Frank's land on this, because the affidavit, as it's written, there is probable cause. And this puts you as the defense in a really hard, really difficult place, because Frank's motions almost are never granted. This one wasn't granted. Convictions are almost never overturned on this basis. And it's interesting to me that this is their first argument, because I always thought, leading with this, if this is the best you got, and that's the message you're sending to the appellate court, if this is the best you got, that's a problem for your overall appeal. But it's not all they say. So you've got that. They want to knock out that evidence. The other thing they want to knock out are the confessions. Confessions are obviously really damning. Jury hears you said you did it. Jury hears you gave some details. A lot of jurors are like, don't really need anything else. He said he did it. That's good enough for me. So we're trying to knock out the confession. And much like the search warrant, the defense has a fundamental problem. This is not a confession given during an interrogation. This is not a confession where someone's will is overborne by a really crafty detective using the Reed technique. And after 8 hours of brutal examination, they break and say, fine, I did it. And then they recant the next day. Not a situation like that. What you have instead is Richard Allen giving a lot of statements at various times to various people while he's being held. Never in an interrogation setting. I mean, the closest to a statement to an official person is when he's talking to his psychiatrist and he gives some confessions then. So if you're going to knock out the confession, the problem is, generally speaking, if you open your mouth and you're a criminal and you read your rights, you're done. That's coming in. I mean, that is like a rule of evidence that's just from hearsay to confessions to everything else. If you open your mouth and speak without being forced to do so while knowing your rights, it's coming in. So we have to show the confession is involuntary. And the law is pretty clear on this. High bar, you have to show that the person's free will has been overborne by threats, violence, promises, or other improper influences. The problem you have here is none of these are present for Allen's statements, which you may recall. That's why in their brief, they're talking about like being held in a Rwandan prison or being held in a prisoner of war camp, that those conditions themselves, even though there's no interrogation, are enough to overcome your will. And they have to say that because there's no evidence of actual coercive state action. It has to just be the conditions of confinement that are so awful that anyone could say anything in that circumstance.
And so the state has to address this, and they do. They're like, look, nothing about his confinement conditions are outrageous or barbaric. So they say in their brief, although small, his cell was the same size as the other restricted housing cells, and it was furnished with a mattress, in a bed frame, a toilet, and a sink. You guys, this is prison or jail. This is not the Ritz-Carlton, right? So what they're saying is this is the exact same conditions as everybody else. He wasn't treated, especially barbaric. He was not a prisoner of war. They go on to say it had a window to the outside. When Allen complained the window was scratched, the DOC replaced it. Small note. I once had a cracked window in my federal government office building because a bird ran into it every single day. Like the same bird would hit it and eventually it cracked. And I made like a request for it because it was like kind of
Probably
disturbing.
cracked to this day.
It was cracked and it had like little blood smudge in the middle. I think it was the same bird because it came back every day to do it. And I like kind of I was like, hey guys, like there's like a government entity that deals with building repairs. And I like submitted a request. I was like, there's this crack in my office building. Kind of looks like prison because it's like very square. And you're right. It probably still is cracked to this day. In the like 7 years I was in that office, it never got fixed. Ever. So the fact, by the way, that this prison window was fixed is no small thing. Okay, but that's not it. The state's brief goes on to say he could dim the light in his cell. Remember, some of the allegations was that it was like an interrogation. It was like bright lights at all times, so it messed with his circadian rhythms, and he didn't know up from down. Like, no, he had access to controlling the light in his room, and he has never claimed that the temperature in his cell was oppressively hot or cold. It's undisputed that Allen was offered regular, nutritionally sufficient food and drink and was given all prescribed medications. He also had access to commissary. He was provided with laundry service and clean sets of clothes every week. Even when on constant suicide watch, he was provided with a suicide smock to wear. Except when precluded by suicide watch status, he received 1 hour of recreation time 5 days a week in indoor and outdoor exercise areas. He was allowed to have a Bible, other books and reading material, and crossword puzzles in his cell. And he was offered a television for his cell, but declined the offer. This is an example of the state clarifying the facts here, because if you've only read the headlines about his confinement, it did seem like he didn't have a mattress. He was, in a straitjacket sitting on the cold, bare floor with bright lights and no food and no outdoor time, and kept in solitary confinement. And here the state is clarifying what the actual facts of his confinement were, which is to say it was the same as anybody else, including the suicide watch component. Like, that wasn't meant to be restrictive. It was for his own safety.
And they keep going. Before I get into that, people always go for gotchas. And so one thing that has really resonated with people is the fact he was held at a prison and not a jail. Now, I think that resonates with people who have no familiarity with prison and jail, because I guess in their mind, they think jails are super nice and prisons are really terrible. Well, they're not. In fact, regularly, we have defendants who are brought from prison to our city and held at the local jail, which is a nice jail, because they need to testify, or there's some sort of, compassionate release hearing, or they, are challenging a 2255. I mean, various things that bring them. And the number of times that a defense attorney will call me and say, hey, do you care if I ask to move this hearing up? My guy wants to get back to wherever he's being held. And I'm like, sure, let's do it tomorrow. I don't care, right? Because they don't want to be in jail, because prison is nicer. It often has far more amenities than your local jail. That's the first thing. The second thing, even if it was wrong of them to hold him in jail, even if their concerns over his suicide were unfounded, it is simply not enough. And you'll never find a case that says it's enough that your confessions are involuntary simply because you're held in a prison instead of a jail. You have to show that because you were held in that prison, your conditions of confinement were terrible. So they send you to Angola or Attica or one of the famous prisons that are really terrible, right? They send you there and you're tortured constantly. And you see this sometimes. I mean, you see people who are sexually assaulted, who are beaten, who really go through terrible experiences in pre-trial confinement. Those kind of arguments, at least you're starting to approach it. But here, you're not even seeing that. You're seeing someone who was kept safe and was provided a lot of different amenities. The fact that he was offered a television and refused it is such a damning fact for him, because it's just a testament to how this wasn't some sort of hellhole that he was being held in. And even if that prison itself was typically bad, he was not being held in some sort of terrible condition, and it continues. And this is, once again, the state doing a really good job of just laying out facts. We're quoting from their brief because the law is pretty clear. Here's the facts. Allen was never held incommunicado. He was appointed legal counsel and received both in-person visits and private phone conversations with his attorneys. He received at least 2 in-person visits with his wife, a privilege afforded no other inmate in restricted housing. He could receive weekly visits from a chaplain upon request. Allen had a tablet in his cell that he could use to make phone calls to family members and others. When he broke his first tablet, we've heard about him doing this, breaking his tablet, he was given a second one free of charge. Also a privilege afforded no other inmate. Allen could listen to music, watch movies, play games, and send written messages on the tablet. And I will just tell you, and we've said this many times, I think a lot of you need to evaluate where you're getting your information, because when someone tells you, trust me, Richard Allen was being treated like a prisoner of war. It was awful. It was terrible. When someone says that about those conditions, they are not shooting you straight. There's no way they actually believe that. I understand the lawyers are having to make the best argument they can, but when you're getting information and you're trying to make a decision as a listener, as a true crime fan, as someone who's just interested in this crime and wants there to be justice in this crime, when someone lies to you about Richard Allen's conditions, hold them accountable for that, because you can read the brief. Every one of those sentences I just read to you is cited to in the transcript. You can go to the transcript and see the evidence for yourself. Whatever you can say about Richard Allen and his confessions and his state of mind, he was not being held in some sort of disgusting hellhole designed to break his will so he would lie and say he committed 2 crimes that he did not commit.
But I have to say, the lines of communication that Richard Allen's team has been impressive, because I have talked to a lot of people when I'm like, well, read the state's brief, see what the facts are about their confinement. They are actually shocked. They're like, oh, really? I really thought that he was just like this crazy person who was turned crazy by the Odinists who were guarding him. Speaking of Odinist. Okay. So a lot of you thought, well, certainly this brief is going to be about how they were not able to present some other dude did it. Not just some other dude, some other Odinist did it. And that's going to be the core of their brief. And it wasn't. Honestly, it was kind of an afterthought. So unlike their... Huh?
It was a throwaway. I don't think if it hadn't been so much a focus of the press coverage in this case, I don't know if they would have included it.
I think the appellate lawyer was like, to satisfy the client, we got to put this in here. But because it is such a weak argument, let's put it at the very end. And that's exactly what they did. So if you remember the whole Odinist, if you haven't been following this case, you have no idea what we're talking about. If you missed it. So the theory, of course, the some other dude did it, is that Richard Allen has been framed by Odinists. And there are Odinists, this Norse cult religion, what have you. They were the ones who committed this murder. And the one that they focus on is other guy. His name is Brad Holder, who was an Odinist, and he was responsible for this, and that they were not able to present this alternative theory, and their case was harmed because of this. Now, let's talk about Brad Holder. And so this is all about clarifying facts here. Brad Holder, they were not allowed to bring this in because if you remember when there was a hearing about whether there's sufficient evidence to tie to the some other dude did it defense, there wasn't. And the trial court said, you can't just bring in, the kitchen sink here when you have no evidence to tie to your other theory. So the state reminds the court here, Brad Holder, this other Odinist who was supposedly responsible, well, he worked at a landfill in Buffalo, Indiana, and he has work records that confirmed he was at work on February 13th, the day of the murder, from 4:55 a.m., well before the girls were ever dropped off at the trail, to 2:45 p.m., after the time the girls would have already succumbed. They would have already been taken at this point. And his gym record showed that he checked in there at about 4:05 p.m. on February 13th. So the entire timeline of the murder is accounted for by independent timestamps here. The operations clerk for the landfill, the only person who could make changes to the electronic time records, also confirmed that she had not changed any of these records, which was part of the conspiracy theory that his records had been changed to provide him an alibi. So Holder's son, who had been, quote, talking to Abby, one of the victims, also had a confirmed alibi. He was in school in Logansport that day, and Buffalo is located 25 miles from Delphi. Now, it takes 30 to 35 minutes to drive from Buffalo to the Monon High Bridge area of Delphi, where the murder took place. And she confirmed that it would not be possible for him to be absent while his time cards show that he was present. Only a small number of people worked each shift, and it would be immediately noticeable if someone was absent or left early, or if a stranger was there filling in. The equipment ran continuously, and if even one person ceased working, it would affect the entire operation. The purpose of this testimony, by the way, was to show that it's impossible there was a mistake, that somehow he was missed and actually not there and committing the murders. Okay. Now, the brief goes on to say that specialized training was needed to operate the equipment, further precluding the possibility that Holder could have sent someone to take his place at work that day. Because Holder could not have committed the crimes, there's no evidence about his Odinism or his social media that could have any tendency to decrease the probability that Allen committed the crimes.
And look, this is straight 403. So we talked about Rule 403 before. Rule 403 says you cannot, neither side, defense or prosecution, applies to both. You cannot bring in information with no foundation that may confuse the jury. So a lot of people just think, well, you're the defendant, you're on trial for life, you should be able to say whatever you want. Okay, maybe that's the system we should have. It is not the system we have. The system we have is governed by rules, and one of them says you can't just throw spaghetti at the wall. You got to at least have some evidence that, the guy was Italian and loved spaghetti if you're going to start throwing it around. And that's this situation. You want to say it was Odinist. Your whole key to it being Odinism is Brad Holder, because Brad Holder takes pictures of sticks, and he's got a drawing of Odin, and Odin hanging upside down from a tree. And that could be similar to this. And maybe there's a rune on the tree, though they even managed to debunk that in the state's brief. And he has pictures of sticks, and this other guy has pictures of sticks. And it's true, we don't have any evidence they know each other, but maybe he's emulating his pictures of sticks, and they're involved in this together, and they committed this crime together, et cetera, right? The glaring hole has always been that Brad Holder has an ironclad alibi. And it's fun to read this because how vast is this Odinist? How high does this Odinist conspiracy go? I mean, you've got him. This is, we did the Adnan Syed case, and we talked about the time card in that case and the ridiculous theory in that case. This is so much worse, because at least in that case, it is the boyfriend. At least there's some connection. And it's just the time card. I mean, who knows what else is going on? Here, you got the time card. You got the operator saying nobody else could change it. Is she an Odinist? Is she involved? Oh, and not only that, but he goes to the gym after work. So, this builds into that whole, and this is the thing. Think about when people offer you these alternative theories. I'm not going to call them conspiracies, just an alternative theory of the crime. Think about how much they have to start changing the facts and adding things in. We talk about Occam's razor. This is adding level after level. Okay, well, fine. He couldn't have been there when they were kidnapped. Maybe someone held them somewhere, took them away and held them, and then brought them back there later on. And that's when they committed their Odinist ritual later on. No one's saying they were murdered exactly when they were taken. And you just think about all of the things you're having to add in for which there is no evidence. You're just adding these things, not because there's evidence of them, and this is a way to explain it, because you need those things to be true for your theory to work. You're adding factors and adding events that had to have occurred for your theory to work, rather than looking at the evidence and comparing it to your theory. This blows the Holder theory out of the water. There's no way he could have been there when this happened. He wasn't involved. And that means it wasn't Odinist that did this. If he's not there, it's not Odinist. He's the key to their whole theory. He's been the key to their whole theory this entire time. And this completely debunks it. So it couldn't have been Odinist. And because he has this rock solid alibi, the defense can't just offer it, even though there's a rock solid alibi. I had a case not unlike this recently where they wanted to do some other dude did it defense, and the some other dude was literally flying a helicopter when the murder happened. He was literally in a helicopter, a military helicopter, and the guy sitting next to him could say, well, I know where he was. He was sitting next to me in a helicopter, so he couldn't have done it. And then the defense was like, well, maybe he hired somebody. Any evidence he hired somebody? Well, I mean, can't prove it didn't happen. Who did he hire? Well, I mean, we don't know. That's a mystery, you know? And it's like, so you want to suggest that this person did it, even though there is undeniable proof he couldn't have been involved because maybe he hired somebody. It's a similar thing here. Undeniable proof he could not have been involved at the time of the murder, but you want to say, well, maybe they took the girls away and hid them and then brought them back and then murdered them. Don't have any evidence for that, but it's the best we can do, Judge. You should let us make that argument. Never going to fly. No way is the judge going to be overturned for not letting this kind of evidence into this case.
So there you have the state's brief. There's 94 pages. You can certainly read it. We've given you some highlights. I know some people who are just tuning in right now are like, why are they only giving the state's argument? First of all, the trial evidence is very more than enough, shall we say, to support the conviction, but also because, in case you missed it, we are covering the state's response to the appeal here. But like
we did one on the
we did one on the other side.
20 episodes or so. You can listen to that one that we did on that one.
Yes. There's gonna be an argument on this, I guess.
I don't even
arguments know. In Indiana. I don't actually know because, I mean, this is high profile. It's long briefs. Sometimes they you usually have arguments for a number of reasons. Sometimes there's just arguments to have arguments, and some courts tend to have arguments versus others. If it's a very clear-cut case and there's no reason to have arguments, it is more efficient for everyone not to have arguments in this case because it is so high profile. I can imagine they'll allow, if either side wanted arguments, they would probably have arguments, is my guess. But I don't know how Indiana does it typically. But not every case that gets filed has an argument.
It may be the case that Indiana has a practice where if someone is sentenced to life in prison and appeals, they'll have oral arguments. There are jurisdictions that have that. If this were not a famous case, if they don't have that rule and this were not a famous case, there would not be oral argument. Because the problem, one of the biggest problems they have is they don't have a really good legal argument. There wasn't some legal question that was decided, that was hotly contested and was decided by the judge. I mean, think about Alec Murdaugh, right? Alec Murdaugh, if he gets a new trial, it's not going to be because they let in too much 404B evidence. It's going to be because you had a really unusual factual occurrence, a courtroom deputy clerk who's maybe influencing the jury, not something that happens that often, and you have a complicated legal question about what standard you apply to that very rare factual occurrence. That is the kind of thing that courts salivate over and that can lead to a new trial. They don't have that. They have a lot of very standard arguments. Search warrant was defective. Confessions were involuntary. Should have let in some stuff that you kept out. Shouldn't have let in some stuff that you let in. These are all very fact-based. They're just they're not sexy. They're not groundbreaking, and they're not purely legal. And I just don't think, I think it is highly unlikely this would succeed. I mean, this appeal is going to fail. I'm just going to tell you. I mean, this appeal is going to fail. They're going to file a reply brief at some point. The state didn't even take as long as I thought they'd take. I thought they'd, get a few more continuances. They went ahead and filed this. Maybe there's oral argument. I think I could see this being denied before the end of the year, which is not something I expected when I read the appellant's brief. I thought it'd take a little bit longer. I think there's a chance they deny this before the end of the year.
Don't disagree. Don't disagree at all. Even though, isn't that funny? Something that should go relatively swiftly. We're still talking about like an 8-month runway, which
That
is
is
fast.
fast.
Honestly, it's fast for this runway. Okay, should we do a question before we sign off?
Sure. Okay. This question is about the Kelly Fitzsimmons case. I don't know if you followed this. Another case out of Massachusetts that ended in a not guilty verdict, because that's apparently what happens in Massachusetts. But weird case about this ex-cop and the gun and shooting and all this other stuff. But one of the things that's interesting about it, and we talked about this when we talked about the case out of DC with the 3 guys who
covered up
the murder. Yeah, just to call a spade.
On Swan. On Swan.
Yeah.
Oh, Robert Wong.
Robert Wong. Okay. So in that case, it was a judge trial. In the Kelsey Fitzsimmons case, there was a judge trial. She decided to have a non-jury trial. And so this person is really curious about that, wants to know, why do we think she did this? Is it an option for everyone? And do we think this is going to become a more frequent occurrence? And I think that's a really interesting question. I actually didn't realize until we covered the Robert Wong case that it's not automatic. I thought you as the defendant just got to waive a jury trial if you wanted to. At least in the federal system, the prosecution can object. Don't know what the case is in Massachusetts. She obviously chose a judge. I mean, I don't know, Alice. What are your thoughts on that? Judge trial versus jury trial. When do you think you would go for one versus the other?
I think when you think you have facts that are really difficult to overcome on a gut level. So officers, a shooting, those are 2 things that people may not be able to get over. This is kind of like when we talk about voir dire, and there are certain things that just really stick with people, and they're supposed to tell the truth. If you're like, can you get over the fact that this case involves an officer in uniform shooting someone? And some people will say, like, I can't get over that. Like, I can't listen to the facts. If an officer is shooting someone, I'm going to automatically side with the person who was shot. Something like that, where if you have facts that are really hard to overcome, like it's part of a hot topic currently, something like that. I can imagine picking a judge versus a jury, because you're thinking, okay, the judge is supposed to, they see a lot of cases. They're not supposed to let emotions overrun them. And with a jury with 12 people, I may not, emotions might get the better of all it needs is one person that could kind of mess it up for me. Right. So it's tough, because it's also just one person, and it's whether you think that judge is going to rule for you or not. So I think it's more going to be whether it's like a really hot topic of the day.
Yeah. So, I think in this case, so we talked about this in Robert Wong. I am convinced that with those facts, a jury would have convicted those 3 guys.
Yep.
Because I think a jury is more susceptible to saying, I'm not entirely sure what happened, but all 3 of those jokers are involved. They all had something to do with this. I don't know which one held the knife. I don't know which one cleaned up. I don't know which one was the unwilling participant, though, frankly, I think it's pretty easy to figure out those 3 roles. So I don't know all the details, but I'm convinced that guy was murdered. Those 3 know all about it. Guilty. I think you're much more likely to get something like that from a jury than you are from a judge, because I do think a judge is more likely to say, and did say in the opinion, I mean, she basically said in that opinion, I think
they did it.
Involved.
I just can't exactly say which one. And because I can't say which one, then that's not enough. That's really what she said.
Yeah. So, I mean, Jason says if I'm innocent,
was already enough, but
Jason says if I'm innocent, I want a judge. If I'm guilty, I want a jury. I think there's some wisdom to that, but I do think the particular angle of the argument is also important. So in this case, just to read you like a brief synopsis, she was accused of pointing a gun at a fellow officer while he was serving her a restraining order taken out by her then fiance and attempting to shoot him, and is what she's accused of. And she's always said she had the gun because she was going to shoot herself. So very sort of murky factual situation. I didn't watch the trial, but my understanding is the defense attorneys did a really good job in it, sort of sowing doubt here, and that it wasn't much of a surprise that she was acquitted. but it does feel like something where a judge is more likely to say, like, this is, I'm not entirely sure. I just think juries
I can
want to reach
imagine a
conclusion.
jury, like some juries, some people can just hear she has access to a gun and knows how to use it, and she knows how these things are done because she's a police officer, and we know she's getting served with a TRO, and she knows, or restraining order, and she knows what that means, and that's a really messy set of facts that could be really difficult to overcome if there's an emotional gut reaction to that. So I'm
Yeah.
not surprised, honestly, that she chose a bench trial versus a jury trial.
Yeah.
Is it going to be common? No, I actually don't think so, because I think ultimately most defense counsel and most individuals, most criminal defendants think that they can convince a jury of their peers. And you honestly just have a better shot with 12 people. You just have to pick off one if you are a criminal defendant in order to get a mistrial. It's obviously a bigger lift if you are trying to go for a full acquittal, but mistrial's a win. You're not convicted that day. So I don't think it'll become a pattern. And if it does, I don't necessarily think that's a bad thing. I mean, first of all, I just don't think that's going to be the case, but like, it's supposed to be the same standard all along. You still get your same appeal rights. Like, I don't think it's going to be some, these judges are just going to go around letting people off. Maybe not, but
I mean, you're right. You are rolling the dice because there's no mistrial with the judge.
Yeah.
There's no like, I can't decide, mistrial.
Right. They make a decision.
Yeah, if you can't decide, that's not guilty.
And by the way, they write an opinion. That's probably going to be like very reasoned. Whereas remember, the jury just comes out and reads their verdict and they don't have to explain. And so you read the Richard Allen appeal, right? You're kind of like going around all the facts and you debate the record. Whereas the judge like writes an opinion, explains their decision, which is a lot harder to attack on appeal.
Yeah. So there you go. That's our thoughts on that.
Well, great questions. If you didn't already know, if you leave a 5-star review, you can ask a question, any question. It could be about the law. It could be about our favorite ice cream. It doesn't really matter, but we love covering things that you're interested in. So hope you learned something today. Go read the 94-page brief if you so want. We'll see how this turns out. See if Brett is correct that this will be resolved before the end of the year. Hey, it could happen in just 8 months, but let us know what you think at prosecutorspod@gmail.com. Find us on all the social medias at prosecutorspod. Brett, is there anything else you'd like to say before we sign off for the day?
I feel like at some point we'll stop covering this case. I mean, this is a case that's always been important to us. It's a case that I wondered if it'd ever be solved. I was really happy to see it solved. I'm absolutely convinced that Richard Allen is guilty. I want him to stay in prison for the rest of his life because I think he did this horrible thing, and I just don't think there's any question that he did it. I do think, once this is over, you're going to have that collateral appeal. And as I've said before, the ineffective assistance of counsel attack on these two lawyers is going to be beautiful. Like, if that takes 80 years to write, I'm going to live for 80 years just to read it. Like, I can't wait to read it. One thing, we've addressed this before, but while we're here, let's just address it really quickly. Richard Allen did not waive his ineffective assistance of counsel claims by seeking to keep his attorneys at the Supreme Court. He waived his ineffective assistance of counsel claims for leaking the photographs. Like, he cannot now argue they leaked the photographs of these two dead girls that inflamed the public against me, therefore they're ineffective morons and I should get a new trial. That is totally waived. But what happened after that, their performance at trial, their performance in pretrial stuff and filings, that's all fair game. And that is something that I think will be attacked vociferously, maybe with some citations to the state's brief about how poorly they did, because I truly believe they were in this for the documentary. Alice and I were in it. They were doing that when they're filming themselves, sending the Frank's motion, and they're like, for Richard Allen, and they hit enter. That's what they were focused on.
Yeah.
They were focused on getting their pictures and their video on Netflix that they were recording, or wherever that ended up in. Hulu. Great documentary. You should watch it, and you can see what a bunch of idiots they are. And that was their focus, and that was what they cared about. And they got that. But Richard Allen wasn't acquitted. If he had have been, they were going to be celebrities. I think that's what they believed. It didn't work out. So they made a lot of really stupid decisions and did a lot of really dumb things. Fortunately, the bar for ineffective assistance of counsel, really high, and they probably don't meet it. So we probably don't have to worry about that. But the brief about their performance from Richard Allen is going to be golden. Can't wait to read it.
I think that's right. Well, guys, let us know what you think. And this will not be our last episode about Richard Allen. But remember, it's for the girls. When you think about all of these, ultimately think about how the victims' families continue to have to live through this horror. And finality is something that we strive for in the justice system. There's not yet finality for these girls and their families. So just remember that. This isn't just some YouTuber's fun clickbait game. This is real people's lives. And think about that in what you consume as well. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Okay.
We have ads today.
We'll stop recording that if you want to hang out for ads to the 130 of you who are here.
Wow.
Do that.
I always forget to look at how many people are here. I just assume it's like the two of us.
If you don't want to hear ads, you don't have to stay.
You don't have to look, but it's pretty funny usually.
All right, Richard Allen.
This is LB. Let's just say LB Delphi states response to appeal. There's so many.
Let's see.
We have none for legal briefs. We have to do BetterHelp again. I thought we just did like 5 of them.
So check that. And
you're right. It might be attached.
Yeah, because
I was like, we just did that. Let's see what this is. We did. Hold on. Let's start recording.
All right, hold on.
I have some good content.
hold on for you.
Okay. Take your time.
I
this
messed up.
You're right. BetterHelp is already recorded.
Great. Okay, let's see.
Tell me when you're ready to record, because I'll just say it on here.
All right, I'm ready to record when you are.
3, 2, 1, record.
Okay.
No ads for legal briefs.
None at all?
No live reads.
Okay.
There's a Pluto TV pre-recorded ad.
Gotcha.
And then BetterHelp on prosecutors is the audio's already in there.
Great. All right, what were you going to say?
Oh, today was field trip day for 2nd grade.
Oh, nice.
We went to one of those like American villages.
Oh, nice.
It was awesome. Like, I didn't know what to expect. I'm not exactly sure how it's funded because it was like a whole
cocaine.
It was like they had all these method actors. They were all in character. There were red coats running all around. And like, it was like a 3-hour-long play, but the kids were like part of it. And they loved it. The kids loved it, but it was like very involved. They like ran through the whole Lexington and Concord Paul Revere ride, like in this like built town. And I was like, this is like, if I learned about Paul Revere's ride this way, I totally remember it.
That's pretty awesome.
Yeah. So anyways, great job. I don't know if those were like college students just like getting their acting credits, but they were really good. Nobody broke. I mean, these kids were like picking their noses and, you know.
Did you ever get anything from Poshmark?
I bought something, yeah.
Okay, that's good.
I did that call with them.
I've been trying to find something. There's just so much. It's a massive website.
It is like, and then it gets a little addictive in a bad way. Like, not because you want to buy things. It's just like, surely I'll find something. It's like
so
thrifting.
much.
You know, that's the whole thing. Yes, I bought something and they like are very specific in what they want us to talk about.
Okay.
They want us to basically talk about the high-end stuff, not like fast fashion. They want to be like, I found this like $500 dress there, you know.
Yeah. I got some pretty nice watches on there. Okay.
Oh, nice.
I'm trying to find a watch. I was thinking maybe I get a watch. But
okay. That's cool. Okay. You want to do Lola first? Lola.
Let's do Lola. Love Lola.
Okay.
Do you want to lead it off or do you want me to?
Your personalization is so good. Why don't you start with the personalization and then I'll do whatever other bullet points.
Guys, we are back with one of our absolute favorite sponsors, Lola Blankets. Look, I could tell you all about these blankets. I could tell you about how wonderful they are, about how warm they are, about how soft they are, about how great it is just to curl up underneath them at the end of a long day. And all of that is true. But the thing I want to talk about is how I give everyone I know a Lola blanket. I've already told you I gave my mom a Lola blanket for Christmas. I'm giving myself a Lola blanket for basically all of the various holidays that come. And my brother-in-law, congratulations to him, he's getting married. Guess what? Don't listen anymore if you're listening, brother-in-law. Guess what they're going to get for their wedding gift? You guessed it, an extra large Lola blanket, because there is nothing more wonderful, more luxurious, more just happiness inspiring than a Lola blanket.
Brett's not wrong. I mean, Lola is the world's #1 blanket. It's crafted with ultra soft luxury faux fur and a signature 4-way stretch that sets it apart. It's sitting on my couch right now, and every morning, all 4 of my kids fight over who gets to use it. And here's the great part: because it's so large, they all fit in it, and they love it. It's machine washable. It's double hem for durability, and it stays flawless. With all my kids using it, I'm washing it constantly, but there's no pilling, no shedding, even after repeated washes. And one Lola instantly elevates your space. It's unbelievably soft, beautifully designed, and makes your home feel cozy and curated. Lola Blanket has collabed with a number of amazing designers. They've done limited editions with Tezza, Harmony Bows, and I don't know if is it Bows, Harmony Bows? I'm not good at this. They've done limited editions with Tezza and Rachel Parcell, but you've got to move fast because these drops always sell out. I have the extra large, and it's massive. They call it the biggest blanket on the internet. For a limited time, our listeners can get 40% off select Lola Blanket products with code prosecutors at checkout. Just head to lolablankets.com and use code prosecutors to get 40% off your order. After you purchase, they'll ask where you heard about them. Please support our show and let them know we sent you. Wrap yourself in luxury with Lola Blankets. That was like a 4-minute ad.
It was.
I love it.
Changed my life. Love Lola.
It's so great. I finally stole it back from Squanto's bed. It's like 80
It's currently
degrees.
on my couch.
It's like 80 degrees.
It's a
and
little
I finally,
warm.
It's a no, I know, but like
Great.
he loved it so much, you know.
Well, I'll tell you,
Okay.
what my kids love it is when they get out of the shower,
It's great.
they curl up underneath it.
It's pretty great.
Anyways, all right, OneSkin.
OneSkin. I'll start. Okay,
OS1.
let's see.
OS1.
OS1. Hyaluronic.
Know what you can do with OneSkin. Gentlemen, OneSkin's not just for the ladies. Get yourself a syringe.
Oh my goodness. All
Don't actually
right.
recommend that, but unless you're in the Olympics, in which case, go for it.
Guys, a lot of skincare looks good on paper, but it doesn't really deliver results. Or even worse, you're sold on the idea that you need 10 different products to have an effective routine. That's why OneSkin really stands out. Their products aren't about hype or fancy packaging. It's real science. The brand was founded by longevity researchers who asked a simple question. If visible skin aging is driven by damaged senescent cells, what if you could slow down that process instead of just covering it up? That research led to OS1 OneSkin's proprietary peptide. It's the first ingredient proven to switch off those damaged senescent cells, actually slowing skin aging directly at the source. This is serious science that fits easily into my existing routine. And every time I use OneSkin, I'm giving my skin a clear signal to repair damaged cells, support collagen, and to strengthen my skin barrier. You guys have always heard, I'm busy. I'm running to court. I'm running to record a podcast. I'm trying to get my 4 kids to soccer practice, to school, what have you. I don't have a ton of time to take care of my skin. But with OneSkin, they make it so easy. When I use their eye cream, I can absolutely feel that my skin is feeling so much better, even with the changing temperatures and the changing humidity. I know I'm giving my skin real science-backed care.
Guys, in my house, my wife tends to use the OneSkin products, but I will tell you, I was skiing recently. I was up in the mountains, forgot to put on the sunscreen. It was kind of hot. It was weird. It was like skiing in 40-degree weather, and I got sunburn. I got windburn. My skin was all cracking and peeling, and it didn't feel great. And I stole some of the OneSkin from her, and I rubbed it on my face. And let me just tell you, it was amazing. So, guys, don't sleep on OneSkin. Born from over a decade of longevity research, OneSkin's OS1 peptide is proven to target the visible signs of aging. It helps you unlock your healthiest skin now and as you age. For a limited time, try OneSkin with 15% off using code prosecutors at oneskin.co/prosecutors. That's 15% off oneskin.co with code prosecutors. After you purchase, they'll ask you where you heard about them. Please support our show and tell them we sent you.
Didn't know where you were going with that skiing.
Poshmark. I was on the ski jump and I thought, how can I go further? Well, then I thought about OneSkin and their hyaluronic acid. Okay.
And I thought, I believe I can fly.
I believe I can fly.
Okay.
I went meters further. You wouldn't believe the growth
Oh my
in
goodness.
my distance.
It's a family show. It's a
I
family
was able
show.
to travel.
Okay, Poshmark.
Okay.
Poshmark.
Poshmark.
Okay, let's see what they say. Poshmark.
I feel like I should start, and
Sure,
then you
sure.
should do personal use, and then you should do the
I got it. My $500 dress. It came.
Pharmasource Rex. You don't look a day over 30.
You have to go younger than that. You have to say not a day over 25.
Well, she's turning 40, so I feel like a decade's pretty good.
No, you got to go down to 25. All ladies know that.
That would be a
decade's not
lie,
enough.
though. She wants the truth. You don't want to lie. You don't look a day over 3. I mean, that's like ridiculous, right? Anyways, okay.
Oh my
Let's
goodness.
see. All right. So I'll start. I'll talk about it for a little while,
Okay.
and then I'll let you talk about what you did.
Okay.
Okay. Whew. Guys, if you're like me, it's always hard to find exactly what you're looking for. You got things, jackets, watches, cufflinks, all these things that you want. You're looking for the perfect item and you can't quite find it and you feel like you're missing out on something. Well, let me tell you, that's where Poshmark comes in. If you've never been to Poshmark, they have so many wonderful high-end products at a discount. Poshmark is the leading fashion resale marketplace shaped by real people and real style. Millions of new and pre-loved items, from daily wardrobe staples to vintage and luxury fashion. Archive-worthy pieces you thought you missed forever. Current essentials, one of one vintage finds. It's all there.
So probably like a lot of you, I have a text chain with my best girlfriends, and we are constantly trading ideas of our wish list dresses. And I was eyeing this beautiful Kiara Boney dress. Honestly, totally out of my budget, but I just loved it. And I kept looking at it. And I thought, there's no way I can spend this much money on it. And one of my girlfriends said, have you checked Poshmark? So I jumped on Poshmark, not thinking that they would have something so nice. And I searched it. My goodness. The exact dress I was looking at was for sale, almost incredibly new, at a fraction of the cost. I bought it right away and it arrived yesterday. Guys, it's a dream. I can't believe I was able to get this amazing dress for a fraction of the cost. Now I'm kind of hooked, and I am looking for all my favorite brands on Poshmark first. And you should too. New deals and styles are listed every day, so don't wait. Download the Poshmark app and use code prosecutors when you sign up to get $10 off your first purchase. Or shop now at poshmark.com/prosecutors and get $10 off your first purchase. That's poshmark.com/prosecutors.
Maybe I will get a man purse. Bad idea. A merce? I know what they called it in Seinfeld. A merce?
That's what they called it in Friends too.
In Friends? Oh, maybe it's Friends.
They may have
Friends
said it
and
in
Seinfeld.
Seinfeld. The two of them, they've shared jokes.
Which one had the bro? Was that Seinfeld?
No, that was Joey. He had the
That
bro,
was Joey.
the bro.
He had the bro. Oh, man.
my
All right. That's ads.
Okay, let's stop this.
Let's see.
Are
Are we recording tomorrow night, too?
6. Yeah, sure. Export.
We'll do Songbird Row Part 3
so
tomorrow.
sad.
So sad.
It really is so sad.
So sad.
We had people over for dinner last night, and whenever people realize that you talk about true crime, that's all they want to talk about, right? So, what 2 cases do you think people ask? Or no, what 3
Savannah
cases?
Guthrie
No, but that's a good guess. That's actually a good
The
guess.
last time I was in a mixed,
I'm trying to
they were
think.
like, "What do you think about Savannah Guthrie?" And I
They
was
asked
like,
about John Bonet.
John
They
Bonet.
asked about Adnan, and then the third one, Karen Reed.
God, Karen
And
Reed.
guess what? They were Reedies.
Oh no!
And I like crushed them. I was like, clearly, we're all in good company here. I was like, yeah, she totally hit him. And they're like,
God.
what? How could you? But then I was like,
looked
we're
at
in
the
company. I
facts.
can't just like unleash, you know? But anyways.
God. That civil case is still ongoing. I have no interest in covering it at all.
No, not at all. And it's bad because in the cases I really don't enjoy, when they're like, why do you think, they're like, what piece of evidence convinced you that she hit him? I was like, go listen to our 12th part.
I don't know, like the pieces of her tail, like
I
embedded in
said that.
clothing
I was
is a
like the
pretty big one.
embedded fibers of, you know,
The fact that
that-
like 10 seconds after she hit him, she called him like cursing him.
yeah.
The acceleration. There's
Oops.
that.
They were like, well, what about the glitched security tape? I was like, okay, glitches happen first of all, but it doesn't matter because her own ring camera caught the busted out tail light in the first place.
Yeah.
Hours before.
I'll never understand that case. I will never understand it.
Intelligent, and I don't even find it interesting. That's the thing. Like,
and we covered
John
it so many
Bonet,
times.
I find
John
theory
Bonet's
interesting.
fascinating.
Right? And
Yeah.
it doesn't offend me either when people are like, oh, it's so clearly the family. Like, I get where that comes
totally
from.
get it.
And honestly, like a huge, that was the narrative for so long. Like, I'm like, yeah, let's engage in this. And like, I get Adnan Syed because there was like
There's a huge serial. Yeah.
Yeah. There was like all the,
You know,
like,
I was thinking
Karen
about
Reed.
this today. I was listening to our second Flight 19 episode.
Yeah.
And I was thinking about how for so many years, I just thought these 5 guys, they took off, they flew off on a bright blue sunny day. And then all of a sudden they're caught in some weird vortex. They can't find their way back, and weird weather, and they just vanish into thin air. How could this possibly happen? That's what I always thought.
Yeah.
And then you look at the facts and you go through the evidence and you're like, oh,
I know exactly where they are.
I know exactly what happened. Yeah. And it's just funny. Like so much of it is just, oh, it's like John Benet Ramsey. I mean, if you haven't gone through it,
if you just read tabloid,
obviously it's the family.
Like tabloid magazines at checkout, which is what I did for many years. Totally thought Patty did it. Man, what a terrible 9-year-old. Like, you know,
I thought it was all going to be, did he do it or did she do it? When we did it, I thought that was going to be what it comes down to. Did he do it or did she do it? And it's like, oh yeah, neither one did it.
Yeah.
I don't know. It's just, I don't know.
And they were like, a couple of them were like, well, I thought it was I thought it was mom. I'm like, what about that letter? I was like, exactly. What about that letter? And I kind of went into it. Like, oh, I hadn't thought about that. You know, that's basically like direct quotes from all these movies that they didn't watch and they didn't have Google back then. But anyways.
I thought our presentation we did. So we did a presentation to the 11th Circuit.
It was awesome.
On the John Benet Ramsey case.
I think they liked it.
I thought they liked it too. And it was, I thought the way we did it was great. Like we actually showed the movie.
It's just so stark when you show the movie and then you see the letter and it's just like bang, bang. It's like movie quote. When it's
like, don't try and grow a brain, John, and then speed. Don't you dare try and grow a brain, Jack. And it's like, these are the same. Like this is obviously a quote from Speed. Anyways.
Agreed. Anyways,
well, this has been fun.
Anyways, I don't think I made friends last night.
That's fine. You don't want to be friends with those kind of people anyway, right? It's like Pharmasaurus and her Murdaugh love. Like, what are you gonna do? You just deal with it. You just deal with it and move on. You know, so that's how you have to do it.
You guys, all
right, guys. We'll be back tomorrow with more. Join us then, and we'll visit with you soon. Until next time. Farewell. Bye, everybody.
Bye, y'all.
Thanks for joining us.